This is a predetermination hearing under IA 2021-006. Present is myself, Chief Coffin, Lieutenant Mark Severance, Officer Christopher Beatty, and Greg Cook. Greg, what is your official title with IUPA?
Business agent.
Business agent. I can't get it right. Okay, so the purpose of this predetermination hearing is to give you, Officer Beatty, a chance to provide any information that I may not have in order to make a decision, or to give me any information that you feel is important. Floor is yours.
Hindsight, I should have investigated much deeper than I did before detaining him. So I already told Lieutenant Severance that I understand that I'm in violation of that. When during the call, I was under the impression that the way he made it sound that he was actually on private property and trespassed, that he was asked to leave, and that his waitresses were scared. So after investigating that, I found out there was nothing, and unhandcuffed him and made him write and told me he was free to go. I felt that I did it in a professional manner, and obviously was unaware that he was who he was. Not that that matters, but looking back, hindsight, I could have investigated with Galt standing there further, or had the information that Galt had. Either way.
Okay. Anything more?
No, sir.
Man,
Yeah, so I'm fine looking at it.
This is kind of he was baiting.
No question.
No question about, and he baited him, and he's admitted to making some mistakes there. Don't think it was intentional. Didn't go in there to intentionally. It wasn't a for lack of a better term, pissing off the police thing or anything like that. I watched the video. My opinion, I didn't think it was that bad. I think the guy had a minimal detention. He wasn't thrown to the ground. He wasn't tased. Was it did the violation occur? Yeah, he did procedurally, but he also didn't go into it looking to do that. It was a mistake, and I think all of us sitting here have been police officers. I think mistakes have been made in all of our careers, and especially with this, this guy was probably, in my opinion, doing stuff that would elicit the very call that came into to dispatch that he wanted in order to create the confusion. He's not new to this, and I think that should be given some consideration. And he walked blindly right into it. Both of the officers.
I will tell you that less than a half hour before this, he came and tried to bait me in the commission meeting. Right. And I didn't fall into the trap. I think that sometimes, I'll choose the right words here. I don't know if officiousness or whatever is an issue with officers. I think that sometimes officers should just take a second and just take a hot minute or a deep breath and say, what is going on here? And when someone challenges us, not take it personally. Yes. Not challenging me or you or whatever. They're challenging the uniform and the badge. It's like we just happen to be wearing it, so we shouldn't take personal offense to it.
Right.
I can say I don't ever take it personal. And watching the video, my voice is never raised. It never sounds like I'm backed into a corner. To me, it's not personal. I don't wear this badge. I wear it with honor, but I don't wear it like I'm the police, like some people. I'm going to stay where I'm going to stay, regardless of what you think.
Okay, so then why the conversation about whether or not someone is entitled to an attorney, and then the response of you get an attorney in court, not out here?
Because we don't ever call an attorney to the scene.
And do you think that's the appropriate response, or would it be this is, either yes it is a custodial interrogation or it's not a custodial interrogation, and that determines what an attorney is, as opposed to you don't get one out here. I'm just asking a question.
I mean, it's not, I've never used that word before. I've been asked that several times, and I just tell them that we don't do attorneys on the side of the road. That's what the court system's for.
Okay.
That's not, you could watch the video, that was not said like with anger or malice. It was just, you don't get one of those out here. You get it in court, but out here we're trying to figure out, we're doing an investigation to figure out what laws were broken and what wasn't, and whether you need to go to jail or not.
Okay. Anything else from either one of you?
No, sir. No, sir.
Okay. Then the time now is approximately 2:38. That'll conclude the predetermination hearing.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced investigations, etc. And let me just start this off with, if you're law enforcement, if you are an FTO, if you are a law enforcement supervisor, you're probably not going to like this video. You're probably not going to like what I have to say. So if you're really set on your ways of the old school mentality of investigative detentions, Miranda, and what I mean by that is, if you are taking the information that you know about investigative detentions and Miranda from things that you've heard, you've never actually looked at the case law yourself, you've never actually flushed through what it is you're actually saying in a meaningful way, you're probably not going to like what I have to say. Because instead of just, falling back on historic lore of what my sergeant said or what my FTO said, I'm just going to give you what the Supreme Court says, because that's really all that matters. And so, again, if you're law enforcement, you're probably not going to like this video, so feel free to just tune out now, and I will just speak to the everyday citizens here. So as we can see from this video, this is internal investigations that's happening. Long story short, this police officer illegally detained somebody for an investigative detention without reasonable or articulable suspicion, without probable cause, without the legal, without having a legal authority to do so. And here he is in this. And so one of the things that I just want to kind of talk about, we're going to talk about investigative detentions. We're also going to talk about Miranda. But this is what I really want to honestly say. And again, this is going to upset law enforcement, and that's fine. But this is this is just my beliefs, right? This is just what I believe. That this is something that is important to me and me only, and I'm only speaking on behalf of myself. But if you are in law enforcement and you can't articulate what reasonable articulable suspicion is, like you can't define it for me like that, you have no business being on the road at all. You have no business being in law enforcement. If you've graduated from a police academy, if you completed an FTO manual, if you're operating independently and you don't know what reasonable articulable suspicion is, you have failed the citizens that you are supposed to be protecting. Your agency has failed the citizens, and your agency has failed you. And you shouldn't be on the road, and you should absolutely give back your badge and your state issued equipment until you are ready, or your agency issued equipment until you are ready to actually be there on the road, because this is the building block of what we do as police, as law enforcement. And if you don't understand the basic foundational principles of policing, I don't know how you do it effectively. And you don't. And this idea that we simply gloss over, right? We simply gloss over an illegal detention, the violation of somebody's civil liberties as, oh, this is just a really good learning tool, is absolutely ridiculous. And quite frankly, it's disgusting. It really is, because this isn't just, oh, I made an oopsie. No, you violated somebody's civil rights. You violated rights that you affirmed that you were going to defend, right? So you're slapping in the face the very fabric of what it is that you've sworn an oath to. And so if you don't understand the levity there, you definitely don't need to be in this line of work. Now, unfortunately, if we were to actually hold that standard and we were to take every cop off the road that couldn't articulate what reasonable articulable suspicion was, I believe our police force would drastically be reduced 90+%. I really do. I really do. And not only that, if you were to ask people, well, what is reasonable articulable suspicion, and name some case laws that articulate and affirm what it is that you're saying, you would lose even more. And so it's very unfortunate. So if you don't know what reasonable articulable suspicion is, you're going to know it by the end of this video, and you're going to know where to find it as well. And so when we're talking about this, right, well, what is reasonable articulable suspicion? Well, as you can see on the screen here, this is something I teach in my course. So this slide comes directly from my course that I teach. And so reasonable suspicion is a legal standard that falls between a mere speculation or hunch and probable cause, which is the higher standard, which is a higher standard. So it is a subjective assessment made by the observer, so law enforcement, that is based upon specific articulable facts and reasonable inferences drawn from those facts. These facts may lead an observer to suspect that an individual has been or is about to be involved in criminal activity. So how I break this down even further, because for law enforcement, while that is a very good academic transcript there, you need to break it down further. And so what I tell people is what facts and observations would lead you, a reasonable person, to believe that criminality is at foot, right? So what facts do you have and what observations do you have that would lend you to believe on a reasonable level that crime's happening? So that's just a very basic elementary statement, but that's really what it is. So what facts do you have, right? What facts are you depending on? What observations are you seeing that are lending to you believing that you have a crime that you need to obviously intervene in? And so when we're talking about the case law, here you go. Reasonable suspicion case law. You have United States v. Cortez, 1981, United States versus Socolow, 1989, Prado v. California, Kansas v. Glover, Terry v. Ohio. There's many more, but these are kind of the bulk of what especially your average patrol officer is going to want to lean in and depend on. And these are frequently case laws that if they are writing good reports, they should be referencing these reports in their everyday encounters with law enforcement, especially when it comes to reasonable articulable suspicion. And so why this matters, right? So we move forward with this, and we see, okay, well, what is a seizure? And we talked about this before. Torres v. Madrid, a seizure, the United States Supreme Court holds that the application of physical force to the body of a person with the intent to restrain is a seizure, even if the person does not submit and is not subdued. And so that's important, because when a police officer is enacting force upon a citizen, they're using that force, that is considered to be a seizure. So in this case, with this officer, when he stops him, says he's not free to go, and handcuffs him, he has absolutely seized this person. This person is not free to go. They have handcuffs on him, so therefore they are seized. And the only way you can seize somebody is if they're detained. And the only way to detain somebody is with what? Well, I'm glad you asked. So we look at Texas v. Brown v. Texas, 1979. We've talked about this in length. The Supreme Court has affirmed that law enforcement needs a reasonable articulable suspicion in order to detain and compel somebody to identify themselves. So before you can stop somebody using force and compel them to identify themselves, you have reasonable articulable suspicion. If you don't have reasonable articulable suspicion, which we had defined earlier with the case law, you don't have the legal right. So any detention you make without reasonable articulable suspicion will be a violation of somebody's rights. How many times do you think that happens every day? I don't even want too many. One time is one time too many, but this happens all the time. And so that's a problem, because as a police officer, reasonable articulable suspicion is not hard to get, folks. And so when we're having law enforcement that are violating people's civil rights because they're not trained up, that's ridiculous, right? Again, you should not be a police officer on the road if you don't understand when you can and can't stop somebody. That should go without saying. But again, you have this officer who's been an officer for a few years, and the idea that he's just like, oh, this is a good training tool, guys. This is a good training tool is ridiculous. I'm sorry. It's just, it's flat out disgusting. And so it's just incredible to me. And then the second portion is, it's so funny how they're making the officer seem like the victim here. Well, he baited me into violating his rights. So you're telling me that you don't have the gumption and self-control because somebody holding a camera and saying mean things to you, that's what it took you. That's all it took for you to violate somebody's rights. You know what I mean? Like the idea that somebody can bait you into violating their rights when it's 100% preventable is just, I don't know. It's a mind numbing. It's mind numbing to even I guess what I'm trying to say, the amount of mental gymnastics you have to do to even try to make that comprehensible. It's more than what I'm willing to, it's more than what I'm willing to partake in. So there we go. We got that done. So if you're watching this and you're just wanting a very down and dirty, this is something they should have taught you in academy, but they didn't. There you go. You just 10 minutes of your time there. Boom. You know everything you need to know as far as stopping somebody for legal detention. Literally, it's not that hard, academies. It's not that hard, FTOs. And so the next thing we're going to look at is this Miranda issue, because it's funny because the IA supervisor did bring up the Miranda thing. So let's talk about it. And this is something that I think cops don't have a good grasp and understanding on is Miranda. They certainly don't. In fact, I know this is also something that's going to be very controversial. When I went to my first advanced investigator course, not as an instructor, but just going through the course, when I went through it, one of the things they asked us about was where do we think most officers get wrong with interviews and things like that. And I mentioned Miranda. I think officers over Mirandize and they get the idea of Miranda completely wrong. So for the first thing we have to realize is Miranda is only for custodial settings, right? It is an in-custody admonishment that you need to give to somebody pursuant to in accordance with Miranda v. Arizona. And there's a few other Miranda case laws, but for what we're going to be talking about specifically, we can just 100% focus on Arizona, Miranda v. Arizona. So this is the Miranda warning, as you can see here. So I'm going to read this to you, and I want you to really think about what it is you're saying, right? Because this officer, right, detained somebody illegally, read Miranda, and then when that person lawyered up, told him he couldn't have one, right? And so let's just really, let's talk about what it is that we're saying here. Miranda warning. You have a right to remain silent, okay? Anything you say can will be used against you in court. You have the right to talk to a lawyer for advice before we ask any questions. 3, you have the right to have a lawyer with you during questioning. 4, if you cannot afford a lawyer, one will be appointed to you before any questioning if you wish. 5, if you decide to answer questions now without a lawyer present, you have the right to stop answering at any time. Waiver. Do you understand the rights? I've read them to you. With these rights in mind, do you wish to speak to me? Now, what's very interesting, and if you guys haven't caught on, that's fine, but this is something I teach officers, right? So if you're going to read Miranda, what does number 4 mean to you? Honest question, what does it mean to you? If you can't afford a lawyer, one will be appointed to you before any questioning if you wish. You are telling them, I mean, this is you saying this. You are saying this to your custody. Hey man, if you don't have a lawyer, if you can't afford a lawyer, we'll get one for you and then we can keep talking. I'm going to get one for you. That's what you're saying. So if you don't have the ability to go good on your promise, because you're making an affirmation to them, you're saying if you want a lawyer, we'll appoint one to you and we'll keep talking if you wish. We have no problem talking to you with a lawyer and we're going to give you one. So if you read him Miranda and he asks for one, and then you say you can't have one, you're going against the one thing that you're saying. I always bring this up in trainings with cops, and I get this look like, I never thought about that before. And so it just goes into this mentality that cops, number one, don't know the law. They don't know case law. And then now they're reading templated, because on the report they're going to say, I read Miranda from a pre-printed card. They're going through all these templates, and they don't even know what it is they're saying. They don't. Because what happens? Okay. I'm under arrest. I'm handcuffed. You're reading me Miranda. Okay, cool. I'd love to talk to you. Can you get that lawyer that you told me you were going to in step 4, please? And then you look at them like they're crazy? I can't. So, law enforcement, do better. If you're going to read this to them and then they're going to ask you for the very thing that you're affirming to them, can you just not act surprised? Please? Please and thank you. Just don't act surprised because you look ridiculous. so there you go. There's just something real quick, and I'm glad that this video kind of highlights that, because I talk about this all the time, and people tell me, I guess nobody's ever asked me that, and I'm like, well, that's good, because I've totally seen it happen before, and then I see a video where it actually happens, and there's an IA involved, so it's like, okay, cool. So people in the country are seeing the same things that I've seen, and you know, I have to hand it to, there's some departments out there that I'm surprised that they don't get into more lawsuits than they do, but it's just by and large, people, both cops and citizens, they don't know what they don't know. So there you have it. Hope this video was helpful for you guys. If you have any questions, please leave in the comment section below. And honestly, tell me, what do you think? And if you're a cop and you're still listening to this, when you read Miranda, what does step 4 mean to you? Like, honestly, what does it mean? What does it mean to you? How many times have you, as law enforcement, read Miranda and then ever tried to talk to them again once they have a lawyer? Other question, right? So again, the words you say matter, you know, and the actions you take matter. So let's not violate people's rights. Well, as always, guys, long live the Republic.